Hello and welcome to the Prelims Practice session for the upcoming preliminary examination. Now this video is in continuation with the series of discussion based on the static part of our syllabus. And in this we have taken up questions from some important topics of Indian polity and constitution. So this is the third video in line with the series of discussions related to Indian polity and the constitution. Now in this video we have taken up some important themes that are the governor of a state, the state legislature and the state executive. Again, we have taken up questions related to Panchayati Raj institutions. Then we have taken up questions related to important schedules of the Indian Constitution. Now, one important thing that should be taken care of while reading these topics is that you should always compare the provisions related to the Governor of India with that of the provisions provided for the President of India. And in that line, you should always focus on the key differences between the functioning of the two constitutional authorities. Further, while reading about the state legislature and the state executive, you should again compare this with the functioning and the provisions related to Indian Parliament. And these aspects have been taken care of in the questions that we have formed in this discussion. Further, if you go through the previous year preliminary examination questions, you will find that UPSC has also focused on the key differences in the functions and the powers of the governor of a state and that of the President of India. And in that case, UPSC has focused on the key differences between the powers that have been provided in the Constitution related to the President of India and the governors of a state. So in this video, let us look at the questions that we have framed based on the previous year questions that have been asked from the topics like the governor, the schedules and the Panchayati Raj institutions. Further, for the coming week, you should prepare from the important topics like the political theory. For example, if you see the previous year questions, you will find that questions have been asked based on key concepts in the political theory. For example, in the year 2019, there was a question related to the interpretation of the term liberty. So similarly, you should learn about some important definitions related to important things. For example, the rights, the duties, etc. So now let us start the discussion of this video.
Now the initial few questions that we are going to discuss here are related to the judiciary in India. And before solving these questions, let us look at the way in which UPSC has asked questions related to judiciary in the previous year preliminary examinations. So if you look at the previous year preliminary examinations, you will find that in the year 2019, 3 questions were asked related to the judiciary. Now the first one was related to the impeachment process of the judges of Supreme Court. Further, the second question that was asked in 2019 was related to the judicial review powers of the Supreme Court of India. And then the third question was related to Article 142, which is related to judiciary again. Further, in the year 2017, the question was related to the judicial review. And in the year 2014, it was related to the jurisdiction of the Supreme Court of India as provided in the Indian Constitution. And then the question that was asked in the year 2012 was related to the autonomy or the independence of the Supreme Court of India. Now regarding this first question that was asked in 2019, let us try and find which all statements that are given here are incorrect. So in this line, if you look at the process of removal of a judge of Supreme Court, you will find that a removal motion has to be signed by at least 100 members in the case of Lok Sabha and 50 members in the case of Rajya Sabha. And then this motion is forwarded to the speaker or the chairman in case of Lok Sabha and Rajya Sabha respectively. However, the speaker or chairman may admit the motion or refuse to admit it, which means that the speaker can reject the motion for the removal of a Supreme Court judge even when it has been signed by the requisite number of members of parliament. So in this case, the first statement that is given here is incorrect. Further, the second statement that is given here, that is the Constitution of India defines and gives details of what constitutes incapacity and proved misbehavior of the judges of the Supreme Court of India. And in this line, the Constitution of India does not define as to what constitutes incapacity and proven misbehavior of a judge of the Supreme Court of India. Further, if you look at the procedure of removal of a Supreme Court judge, you will find that the speaker constitutes a committee in the House in which a motion for the removal of a judge of Supreme Court has been admitted. And that committee outlines as to what is the incapacity and proven misbehavior of a particular judge regarding whom the impeachment motion has been admitted in the Lok Sabha or the Rajya Sabha. So by finding the wrong statements, you will find that the option A and D are incorrect here. And if you look at the third and the fourth statements, you will find that the details of the process of impeachment of the judges of Supreme Court of India are given under the Judges Enquiry Act of 1968. And again, if a motion for the impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament, and it should be supported by a majority of total membership of the house and by not less than 2/3 of the total members of that house present and voting, which is also correct. So the correct answer here is C, that is 3 and 4 only. Again, if you look at the second question that was asked in 2019, it reads, with reference to the Constitution of India, consider the following statements. First is that no High Court shall have the jurisdiction to declare any central law to be constitutionally invalid, which is incorrect because it stands against the basic premise of the judicial review which has been provided to the Supreme Court as well as the High Court of India. And if you look at the second statement, it reads, an amendment to the Constitution of India cannot be called into question by the Supreme Court of India. Now, this statement is also incorrect because an amendment to the Constitution can also be held invalid if it stands in contravention to the basic structure of the Indian Constitution. And you might be knowing that the Supreme Court had recently rejected the National Judicial Appointments Commission Act, which was passed by the Parliament, because it was known to be hampering the independence of the judiciary. So the correct answer in this case is D, that is neither the statement 1 nor the statement 2 are correct. Further, if you look at the third question that was asked in the year 2019, it reads, with reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under the Article 142. It could mean which one of the following? So in this line, this is related to the functioning of the Supreme Court of India, and it means that the Supreme Court of India is not constrained in the exercise of its power by laws made by the Parliament. So B was the correct answer here. Further, if you look at this question that was asked in 2017, it talks about the implications of the judicial review. And it simply implies that the power of the judiciary to pronounce upon the constitutionality of the laws and the executive orders. And hence A is the correct answer here. Further, if you look at the question that was asked in 2014, it reads, the power of the Supreme Court of India to decide disputes between the center and the states falls under its. Now, if you go through the jurisdiction of the Supreme Court of India, you will find that its original mandate is to act as a federal court. And because of this, it decides upon the disputes between the center and the states. And hence, it falls under the original jurisdiction of the Supreme Court of India. Further, if you look at this question that was asked in the year 2014, in this, the first statement that is given here is that while appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India, which is a correct statement. However, if you go through the second statement, it reads, the Supreme Court judges can be removed by the Chief Justice of India only, which is incorrect because the judges of the Supreme Court are removed based on a presidential order, based on the process which has been provided under the Judicial Enquiry Act of 1968. Now, if you closely look at the options that are given in this question, by eliminating the second statement, you can easily eliminate the option D that is given here. However, the only option where the first statement which is correct has been incorporated is the A option, and hence simply the option A comes out to be the correct answer in this case. So be aware of the incorrect statements, and after that try and find the correct statements that are found in the different options in the question. Now, by looking at the previous year questions, we find that the process of removal and the appointment of the Supreme Court judges is one of the key areas in which UPSC has asked questions. Again, second important theme is related to the judicial review powers of the Supreme Court of India. And further, the third important area is the jurisdiction and the powers of the Supreme Court of India. So in this regard, this first practice question that we have created is related to the impeachment of the judges of the Supreme Court. So this question reads, consider the following statements. The first is that the President can order removal of a judge only after an address by the Parliament has been presented to him in the same session for such removal. Second is that an impeachment motion for the removal of a Supreme Court judge does not lapse on the dissolution of Lok Sabha. And third is that so far only one judge has been removed by the order of the President. Now in this question, if you look at the third statement, this is incorrect because so far no judge of Supreme Court of India has been removed by the order of the President through the process of impeachment. And hence by this you can easily eliminate the options C and D. And regarding this third statement, you should note that the only case of impeachment that was brought before the Parliament was that of Justice V. Ramaswamy of the Supreme Court between the 1991 to 1993. And in this case, the inquiry committee found Justice V. Ramaswamy as guilty of misbehavior. However, he could not be removed as the impeachment motion was defeated in the Lok Sabha. So you should be aware that no judge of the Supreme Court has been impeached so far by the order of the President. Further, if you look at the first statement, it is one of the important conditions that has been mentioned regarding the process of removal of a Supreme Court judge. And it is that a judge of the Supreme Court can be removed from his office by an order of the President, and the President can issue the removal order only after an address by the Parliament has been presented to him in the same session for such removal. So this condition of presenting the removal order in the same session is one of the key conditions for the removal of judges of the Supreme Court. Further, if you look at this second statement, it is one of the unique things regarding the motion for the removal of a Supreme Court judge which is admitted into Lok Sabha. So this statement, that is an impeachment motion for the removal of a Supreme Court judge, does not lapse on the dissolution of Lok Sabha, is also correct here. Now normally we find that the motions or bills which are pending in the Lok Sabha lapse on the dissolution of Lok Sabha. However, this impeachment motion related to the removal of Supreme Court of Judge does not lapse, and hence this is a unique situation and which should be kept in mind. So the correct answer that comes out in this question is B, that is 1 and 2 only. Further, the second question is related to the jurisdiction of the Supreme Court of India, and it reads, which of the following statements is or are correct about the Supreme Court of India? First is that the Supreme Court is empowered to issue writs for the enforcement of all the rights guaranteed by the Constitution of India. Second is that any suit brought before the Supreme Court of India by a citizen against the centre or a state falls under the original jurisdiction of the Supreme Court of India. Now you might be knowing that the jurisdiction and the powers of the Supreme Court of India have been divided into original jurisdiction, the writ jurisdiction, appellate jurisdiction, advisory jurisdiction, etc. Further, if you read about the original jurisdiction of the Supreme Court of India, you will find that the Supreme Court of India has been given the powers of a federal court. And in this case, the Supreme Court decides the disputes between different units of the Indian Federation. And in these cases, the Supreme Court decides upon the disputes between the centre and the states, or even between the states themselves. Now, this jurisdiction of the Supreme Court has been defined as original jurisdiction because the power of the Supreme Court to hear such disputes is in the first instance only. That means that not necessarily the states or the centre and the states have to approach lower courts before approaching the Supreme Court. This means that in case of disputes between the federal units in the India, these federal units can directly approach the Supreme Court, and hence this is an original power or the original jurisdiction that has been provided to the Supreme Court of India. However, regarding this original jurisdiction, you should note that any suit brought before the Supreme Court of India by a private citizen against the centre or the state cannot be entertained under the original powers that have been provided to the Supreme Court of India as a federal court. So this means that a private citizen cannot directly approach the Supreme Court of India against a case related to the centre or the state government. However, this right has only been provided to the centre and the states, or the states themselves if they are disputing on a matter. And hence this second statement that is given here is incorrect. Further, this first statement that is given here is also incorrect. And this is because the Supreme Court is empowered to issue writs for the enforcement of fundamental rights only guaranteed under the Indian Constitution. And this power has been provided to the Supreme Court under the Article 32, which provides for the writ jurisdiction of the Supreme Court. And in this, various writs like the habeas corpus, certiorari, etc. have been provided to the Supreme Court. So this simply means that it cannot issue writs for the enforcement of all the rights which have been guaranteed by the Constitution of India. So for example, the Supreme Court cannot issue a writ in the case of right to property, which is a constitutional right, however is not a fundamental right. So the correct answer that comes out in this question is D, that is the neither statement 1 nor the statement 2 are correct here. Now, by solving these questions, you might have found that it is important to learn about the process of appointment of the Supreme Court judges, and also you should learn in detail about the process of impeachment or the removal of the judges of Supreme Court. Further, you should also learn about the various jurisdictions and the powers of the Supreme Court of India that have been provided in the Indian Constitution. After this, let us take up the third question that is related to judiciary that we have formed. Now, if you look at this third question, it is related to the judicial review. So it reads, consider the following statements. First is that the Supreme Court exercises judicial review on the laws and executive orders only when they stand in contravention to the fundamental rights. And the second statement is that 9th schedule provides immunity to certain laws from judicial review. Which of the statements given above is or are correct in this regard? Now, judicial review is simply the power of the judiciary to examine the constitutionality of the legislative enactments and executive orders of both the central as well as the state governments. And on examination, if they are found to be violative of the constitution, they can be declared as illegal, unconstitutional, and invalid by the judiciary. So in this regard, the Supreme Court has the power to judicial review various constitutional amendments. It can also review the legislations of the parliament and the state legislatures. And also the judiciary can review the administrative actions of both the union and the state, and as well as other authorities which are there under the state. So in this regard, you should note that the term judicial review has nowhere been used in the Constitution of India. However, various articles that are provided in the Constitution of India confer this power of judicial review on the Supreme Court as well as the High Courts. So the Article 13, which is related to the fundamental rights, declares that all the laws that are inconsistent with or in derogation of the fundamental rights shall be null and void. However, this judicial review power is not just restricted to the laws which are standing in contravention to the fundamental rights. And in this background, the judiciary can also invalidate any legislative enactment or executive order if it is outside the competence of the authority which has framed it. Further, it can also declare any legislation as invalid if it stands repugnant to the constitutional provisions that have been provided in the different parts of the Constitution and not just in the part of fundamental rights. And hence, this first statement that is given here is incorrect. And this statement is incorrect because the scope of judicial review on the laws and executive orders is larger than that of the fundamental rights. Now, simply for example, the Supreme Court can strike down any Constitutional Amendment Act if it stands in contravention to the basic structure doctrine which was formulated under the Keswananda Bharti case. And under this basic structure doctrine, the Supreme Court in its various judgments has defined that federalism, etc. are also some of the basic features of the Indian Constitution. So if any law that stands in contravention to the federal powers that have been defined in the Constitution of India can also be declared ultra vires by the Supreme Court. Further, regarding the second statement, that is the 9th schedule provides immunity to certain laws from the judicial review, you should note that the Article 31B saves the acts and regulations included in the 9th schedule from being challenged and invalidated on the grounds of contravention of any of the fundamental rights. Now, this 9th schedule was added by the first Constitutional Amendment Act of 1951. Now, in the I.R. Coelho case of 2007, the Supreme Court ruled that there cannot be any blanket immunity from the judicial review of the laws which are included in the 9th schedule. And the court in this judgment has held that the judicial review is a basic feature of the Constitution and it could not be taken away by putting a law under the 9th schedule simply. However, one clause that was inserted in this Supreme Court judgment was that the laws which are placed under the 9th schedule after the April 24, 1973 are open to challenge in the court if they violated fundamental rights guaranteed under the Articles 14, 15, 19 and 21. And this clause was inserted because the Keswananda Bharti judgment was given in the year 1973. So the Supreme Court has simply provided that all the laws which are included under the 9th schedule after the Keswananda Bharti verdict are open to judicial review by the judiciary. However, the laws which are there in the 9th schedule which were placed into it before the Keswananda Bharti verdict are still immune from judicial review. And hence the 9th schedule still provides immunity to certain laws from the judicial reviews which were placed into this 9th schedule before the Keswananda Bharti verdict of the Supreme Court. And hence this second statement here is correct. So the correct answer that comes out is B, that is 2 only. So after looking at the questions related to the judiciary, let us look at the questions that have been asked previously in the UPSC preliminary examination related to the governor, the state legislature and the state executive. Now before looking at the questions related to the governor, state legislature and the state executive, let us look at the questions that have been asked previously in the UPSC preliminary examinations. So there were two questions that were asked in the year 2019 and one question was asked in the year 2018. So the question that was asked in 2019 reads, which one of the following suggested that the governor should be an eminent person from outside the state and should be a detached figure without intense political links or should not have taken part in the politics in the recent past. So this was one of the recommendation of the Sarkaria Commission, which was formed related to the federal structure of India. And this commission had the mandate of analyzing the center-state relations. So accordingly, you should also read about the other commission that has been created regarding the center-state relations, and that is the Panchayat Commission. Further, this second question that was asked in 2019 reads, with reference to the Legislative Assembly of a state in India, consider the following statements. So the first statement that is given here is correct. That is, the governor makes a customary address to the members of the House at the commencement of the first session of the year. And a similar role has been prescribed for the President of India, who addresses the Parliament at the commencement of the first session of every year. Further, the second statement that is given here is that when a state legislature does not have a rule on a particular matter, it follows the Lok Sabha rule on that matter. Now, this statement that is given here is also correct, and this statement has been in news several times. So the correct answer here is C, that is both 1 and 2 are correct. Further, if you look at this question that was asked in the year 2018, it reads that the Speaker of the Legislative Assembly shall vacate his or her office if he or she ceases to be a member of the Assembly. And the second statement is that whenever the Legislative Assembly is dissolved, the Speaker shall vacate his or her office immediately. So regarding the first statement, you should note that the Speaker should necessarily be a member of the Assembly. So in case he or she vacates the office of Speaker, so in case the Speaker ceases to be a member of the Assembly, in that case, he or she shall vacate the office of the Speaker. And regarding the second statement, whenever the Legislative Assembly is dissolved, the Speaker shall not vacate his or her office immediately. And it is only after the constitution of new Legislative Assembly that the Speaker will vacate the office. So in this case, the second statement is not a necessary implication of the dissolution of state legislative assembly, and hence this statement given here is incorrect. So in this case, the correct answer that comes out is A, that is 1 only. Further, if you look at these three questions, they were asked in the year 2018, 15 and 14. And this question is related to the governor. The second question is related to the Legislative Assembly and Legislative Council. And the third question is related again to the governor of a state. So the question that was asked in 2018 reads that no criminal proceedings shall be instituted against the governor of a state in any court during his term of office, which is a correct statement. And again, the second statement is also correct. That is, the emoluments and allowances of the governor of a state shall not be diminished during his term of office. So the correct answer that comes out is C, that is both 1 and 2. Then the question that was asked in the year 2015 is that the Legislative Council of a state in India can be larger in size than half of the Legislative Assembly of that particular state, which is an incorrect statement because the maximum size of the Legislative Council can be 1/3 of the total size of the Legislative Assembly. And regarding the second statement, that is the governor of a state nominates the chairman of the Legislative Council of that particular state, is also incorrect. So the correct answer that comes out is D, that is neither 1 nor 2. And again, if you look at 2014 question, it reads, which of the following are discretionary powers given to the governor of a state? Now, if you go through the powers that are given to the governor under the Constitution of India, you will find that the appointment of ministers is a constitutional obligation upon the governor, and it is not based on his discretionary power. And hence, you can easily eliminate the second statement that is given here. And by this, you can eliminate the options A, C, and D. And in this regard, the correct answer that comes out is B, that is 1 and 3 only. That is, sending a report to the President of India for the imposition of President's rule is one of the discretionary powers of the governor of a state. And again, reserving certain bills passed by the state legislature for the consideration of President of India is also a discretionary power of a governor of a state. So the correct answer is B, that is 1 and 3 only. So by solving these questions, we find that various provisions related to the governor of a state are important for us from the preliminary examination. And also, you should compare the powers that have been provided to the governor as compared to that of the powers which have been provided to the President of India. Further, regarding the functioning and the constitutional provisions related to the Legislative Council and the Legislative Assembly, you should always study them in comparison with the provisions that have been provided for the Parliament, that is the two houses, the Lok Sabha and the Rajya Sabha. So while reading the provisions for Lok Sabha, you should compare that with the provisions which have been provided to the State Legislative Assembly. And while reading about Rajya Sabha, you should also compare the provisions for Rajya Sabha with that of the provisions which have been provided for the Legislative Council. So after this, let us take up the practice questions now. Now, if you look at this fourth question, it is related to the powers of the governor. So the first statement that is given here is that the governor of a state shall act in accordance with the aid and advice provided by the Council of Ministers headed by the Chief Minister. And the second statement is that if a bill is reserved by the governor for the consideration of the president but is returned and passed again by the State Legislative Assembly, then it can receive the assent from the governor of the state. Now, regarding the first statement, if you compare the constitutional position of the governor of a state with that of the President of India, you will find that regarding the President, under the Article 74, it is provided that there shall be a Council of Ministers with the Prime Minister at the head to aid and advise the President, who shall, in the exercise of his functions, act in accordance with such advice. However, if you compare this Article 74 with that of Article 163, it provides that there shall be a Council of Ministers with the Chief Minister at the head to aid and advise the governor in the exercise of his functions, except insofar as he is required to exercise his functions in his discretion. So this means that the governor of a state shall act in accordance with the aid and advice provided by the Council of Ministers headed by the Chief Minister. However, he can also act beyond the aid and advice of the Council of Ministers under the discretionary powers which have been provided to the governor. And this particular power has not been provided to the President of India. And this statement is incorrect because although majority of the times the governor of a state acts in accordance with the aid and advice of the Council of Ministers, however, he can also act upon the discretionary powers that have been provided to him. And in that case, the governor is not bound by the aid and advice provided by the Council of the Ministers. Further, regarding the second statement, you should note that when the governor reserves a bill for the consideration of the president, he will not have any further role in the enactment of the bill. And if such a bill is returned by the president for the reconsideration of the House and is passed again, then the bill must be presented again for the presidential assent only. And this is the primary requirement in case of a bill which has been referred to the president by a governor. So this means that if a bill has been reserved for the consideration of the president by the governor, then the role of the governor ends there. And thus, if such a bill is returned back by the president for the consideration of the House and is again passed, then it cannot receive the assent from the governor of the state. However, it will have to receive an assent from the president only. So again, this statement also becomes incorrect. So the correct answer that comes out is D, that is neither statement 1 nor the statement 2 are correct here. So as you can see, we have compared the powers of the governor with that of the president while framing this question. And also we have compared the legislative process of the state legislatures with that of the parliament. So similarly, while going through these topics, you should also study in a comparative manner to get a better grasp of these concepts. With this, let's take up the fifth practice question now. Now the fifth question is related to the state legislatures and it reads that which of the following statements is or are correct about the state legislatures. So if you look at the first and the second statement, it reads that a deadlock takes place when the Legislative Assembly, after receiving a bill passed by the Legislative Council, rejects the bill. And the second statement is that in case of deadlock, the governor can summon a joint sitting of both the houses of the state legislatures. And if you look at this first statement, it is incorrect because a deadlock takes place only between the two houses of the state legislatures when the Legislative Council, after receiving a bill passed by the Legislative Assembly, rejects the bill or proposes amendments. Also, a deadlock takes place when the Legislative Council does not pass a bill which has been referred to it by the Legislative Assembly within 3 months. On the other hand, if a bill which has been passed by the Legislative Council and is referred to the Legislative Assembly, and in that case, if Legislative Assembly rejects that bill, then that bill ends there and then. Thus, a deadlock only takes place when a bill passed by the Legislative Assembly is referred to the Legislative Council, and in that case, if the Legislative Council either rejects the bill or it proposes certain amendments, or it does not take any action on that bill within a period of 3 months. Further, the second statement that in case of a deadlock, the governor can summon a joint sitting of both the houses of state legislatures. Now, this statement is incorrect because the mechanism for the resolution of deadlock is different in case of state legislatures with that of the mechanism of resolution of a deadlock when it takes place in the parliament. So, in the case of parliament, the president can summon a joint sitting of both the houses. However, in case of state legislatures, this mechanism has not been provided. So the question of joint sitting does not arise in the first place in the case of state legislatures. So regarding the mechanism for resolving the deadlock, if a bill is passed by the Legislative Assembly for the second time and is transmitted to the Legislative Council, and if the Legislative Council again rejects the bill or proposes certain amendments or does not pass the bill within 1 month, then the bill is deemed to have been passed by both the houses. Thus, this means that the Legislative Assembly has overriding powers over the Legislative Council, and which is not the case in case of Parliament, where the Lok Sabha and Rajya Sabha have equal powers in case of passing a bill. So, while reading the legislative process, you should compare the legislative process in the state legislatures with that of the Parliament. And this will give you a deep insight into the important concepts and differences between the two processes. Now, as we have eliminated the first and the second statement, we can easily eliminate the options A and D here. So, regarding the third and the fourth statement, you should note that the third statement, that is the maximum strength of the Legislative Council is fixed at 1/3 of the total strength of the Legislative Assembly, is correct here. Again, a resolution for the creation of Legislative Council must be passed by a state assembly by a majority of the total membership of the assembly and a majority of not less than 2/3 of the members of the assembly present and voting. So the correct answer that comes out is C, that is 3 and 4 only. So after this, let us take up the next question. Now the sixth question is related to the discretionary powers of the governor of a state. And this question reads that which of the following discretionary powers of the governor have been mentioned in the Constitution of India? Now if you compare the powers of the governor of a state with that of the president, you will find that certain discretionary powers have been provided in the Constitution to the governor of a state, and such discretionary powers have not been provided to the President of India under the Constitution. Now, some of the constitutional discretionary powers are the reservation of a bill for the consideration of President, recommendation for the imposition of President's rule in a state. Further, the governor can use his discretion while exercising his functions as the administrator of an adjoining union territory. And further, the constitutional discretion can be exercised while seeking information from the chief minister with regard to the administrative and the legislative matters of a state. So if you look at these options that have been provided, the first one reads that the recommendation of a bill for the consideration of the president. Second is that the appointment of chief minister in case of a hung assembly. And the third is that a recommendation for the imposition of president's rule in a state. So if you look at the second option, this discretionary power has not been provided outrightly into the Constitution of India, and hence this second statement given here becomes incorrect, and by this you can easily eliminate the options C and D. However, the first and the third are the constitutional discretions which have been provided to the governor of a state, and hence the correct answer that comes out is B, that is 1 and 3 only. Now regarding the second statement, you should note that the governor exercises certain discretionary powers like that of the president, which are based on the situation that is prevailing in the politics of a state. And accordingly, that exercise of discretionary power is known as situational discretionary powers. And these powers are derived from the prevailing political situation in a state. Now, such situational discretion can be exercised in case of appointment of a chief minister when no party has a clear-cut majority in the state legislative assembly, or when the chief minister in the office dies suddenly. Further, the situational discretion can be exercised for the dismissal of Council of Ministers when it cannot prove the confidence of the state legislative assembly. And also, the situational discretion can be exercised for the dissolution of legislative assembly if the Council of Ministers has lost its majority. Now, such situational discretions are also exercised by the President of India in case of the Parliament. And these discretionary powers are exercised based on the conventions of parliamentary democracy. So it is very important to note that which all discretionary powers have been provided to the Governor of India in the Constitution itself, and which all discretionary powers are situational in nature. And further, it is important to compare the discretionary powers of a governor of a state with that of the situational discretions which are available to the President of India. With this, let's take up the next question now. Now, another important topic in the Indian polity are the Panchayati Raj institutions. So, before looking at these two questions that we have framed from the Panchayati Raj institutions section, let us look at the way in which UPSC has asked questions related to the Panchayati Raj institutions in the preliminary examination. Now, regarding the questions that have been asked in the preliminary examinations related to the Panchayati Raj institution, you should note that 3 questions have been asked in the years 2017, 16 and 15. Now, the 2 questions that were asked in the year 2015 and 17 are related to the main or the fundamental objective of the Panchayati Raj institutions in India. And this question that was asked in the year 2017 is directly inspired from the question that was asked in the year 2015. Now, although the Panchayati Raj institutions were provided constitutional status in the year 1992, the work on the Panchayati Raj institutions had started as early as 1950s. And in the year 1957, a committee was formulated by the Government of India, and that is known as the Balwant Rai Mehta Committee. And this committee recommended the establishment of the scheme of democratic decentralization in the context of developmental planning in India at the grassroots level. And thus the Panchayati Raj institutions were conceptualized for the first time as a system of rural local self-government. And these were trusted with the rural development. And further, they were provided constitutional status through the 73rd Constitutional Amendment Act of 1992. So if you look at this question that was asked in the year 2015, the fundamental objective of the Panchayati Raj system is to ensure which among the following. So in this, if you look about the basic objective of the Panchayati Raj institutions and the way in which they were conceptualized in India, you will find that the key or the fundamental objective of such institutions was people's participation in the development, and third is the democratic decentralization. However, the political accountability and financial mobilization were not the fundamental objectives of Panchayati Raj system, and hence the correct answer that comes out is C, that is 1 and 3 only. Again, if you look at this question that was asked in 2017, it talks about the local self-government can be best explained as an exercise of. And in this case, again, the answer is B, that is democratic decentralization. So you can see that the fundamental objective of the Panchayati Raj institutions was asked in the year 2015, and again it was asked in the year 2017. Now, these questions signify that UPSC always focuses on basic concepts in the Indian polity. So in this regard, you should be very good with the basic concepts and the fundamental objectives of any provision that has been provided in the Constitution of India. Further, various provisions have been provided under the 73rd Constitutional Amendment Act related to the Panchayati Raj institutions. And this question that was asked in the year 2016 is related to them. So it reads, consider the following statements. The first is that minimum age prescribed for any person to be a member of Panchayat is 25 years, which is an incorrect statement because it is 21 years. That is, the minimum age is 21 years for a member to become a member of Panchayat. The second statement is that a Panchayat reconstituted after premature dissolution continues only for the remainder period. Now, this is a unique thing which has been provided for the Panchayats, which is different from the other bodies which are elected, for example, the state legislative assemblies or the Lok Sabha in case of parliament. And this provision was added in order to have simultaneous election for all the Panchayats in a given state. So this statement that is given here is correct. That is, a Panchayat which is reconstituted after premature dissolution continues only for the remainder period. And hence the correct answer that comes out is B, that is 2 only. So after this, let us take up the questions that we have formulated based on Panchayati Raj institutions. Now the 7th question reads that which of the following statements is or are not correct about the constitutional provisions about the Panchayati Raj institutions in India. So in such kind of questions, you should always focus on the word not correct, and you have to find the incorrect statements that are given regarding the Panchayati Raj institutions which have been provided in the Constitution of India. So the first is that the chairperson of the Panchayats at the village level shall be directly elected by the people. Second is that 1/3 of the total seats at all the levels of the Panchayats shall be reserved for the SCs and the STs. And finally, if a Panchayat is dissolved at any time before the expiry of its duration of 5 years, fresh elections shall be conducted. Now, we all know that the Panchayati Raj institutions have been provided at the village level, at the intermediate level, and at the district level. Now, regarding the chairpersons of the panchayats at the intermediate and the district levels, the constitution provides that the chairpersons of the panchayats at the intermediate and the district levels shall be elected indirectly by and from amongst the elected members thereof. So, regarding the chairpersons at the intermediate and the district level, they are to be elected indirectly and not directly. However, the chairperson of a panchayat at the village level shall be elected in such a manner as the state legislature determines, and it is not compulsory that the chairperson of the panchayats at the village level shall be directly elected by the people, and thus this statement given here is incorrect. Further, regarding the reservation of seats in the Panchayati Raj institutions, you should note that the reservation of seats for the scheduled castes and scheduled tribes in every panchayat should be provided in proportion of their population to the total population in the panchayat area. And further, the state legislature shall provide for the reservation of offices of chairperson in panchayats at the village level or any other level for the SCs and the SC/STs. And there is no foundation of reserving 1/3 of the seats of the panchayats for the SCs and STs. And hence, this statement given here is also incorrect. And if you look at the reservation which has been provided to the women in the Panchayati Raj institutions, it is that 1/3 of the total seats have to be reserved for the women at the Panchayati Raj institutions. So don't get confused with the provisions which have been provided for the reservation for women with that of the reservation provisions for the SCs and STs at the Panchayati Raj institutions. And regarding the third statement, if a panchayat is dissolved prematurely, then the fresh elections to constitute a panchayat shall be completed before the expiry of its duration of 5 years, and secondly, in case of dissolution, before the expiry of a period of 6 months from the date of its dissolution. And thus, where the remainder of a period is less than 6 months, it shall not be necessary to hold any election for the constitution of new panchayat for such period. And thus, this blanket statement, that is, if a panchayat is dissolved at any time, so the key point in this statement is at any time before the expiry of its duration of 5 years. So this means that only if the panchayat gets dissolved 6 months before the expiry of duration of 5 years, fresh elections shall be conducted. And again, this statement becomes incorrect. However, in this question, we are required to identify the incorrect statements regarding the constitutional provisions of Panchayati Raj institutions. So thus, in the context of the requirement of the question, all these statements given here are correct. So the correct answer that comes out is D, that is 1, 2 and 3. Further, the 8th question reads that which of the following is or are compulsory provisions under the 73rd and the 74th Constitutional Amendment Act of 1992. First is that direct elections to the post of chairperson at the intermediate and district levels. Second is that every state shall constitute at the district level a district planning committee. And the third statement is that the provisions of these acts shall not be applicable to the 5th and the 6th schedule areas. Now, regarding the first statement, we have already read that the chairpersons at the intermediate and the district levels shall be elected indirectly by the members of these panchayats. And thus, this first statement given here is incorrect. Now, if you eliminate this first statement, you can easily eliminate the options A, B and D. So the correct answer that comes out is C, that is 2 and 3 statements that are given here are correct. Further, regarding the second statement, you should note that every state shall constitute at the district level a district planning committee to consolidate the plans prepared by the panchayats and the municipalities in the district. And also, every metropolitan area shall have a metropolitan planning committee to prepare a draft development plan. So while reading about these district planning committees, you should read about the compulsory provisions which have been provided in the Constitution. So for example, regarding the district planning committee, it has been provided that 4/5 of the members of a district planning committee should be elected by the elected members of the district panchayats and the municipalities in the district from amongst themselves. And this is a compulsory provision. So you should be aware about such kind of provisions which have been provided under the Constitution regarding the Panchayati Raj institutions. And further, the third statement given here is also correct and is compulsory that the provisions of the Panchayati Raj Act shall not be applicable to the 5th and the 6th schedule areas which have a different mode of governance which has been provided under the Constitution under the 5th and the 6th schedule to protect the rights and interests of the tribal population in various parts of India. And we note that the government has formulated the PISA Act of 1996 to extend the Panchayati Raj institutions to the 5th schedule areas. So thus the third statement given here is also correct. So C is the correct answer, and after this let us take up 2 more questions. Now, the last two questions in this discussion have been formulated from the schedules of the Indian Constitution. And you can see that previously 5 questions have been asked from the important schedules of the Constitution of India. And you can see that in the year 2019 itself, 2 questions were asked from the schedules. Again, there was a question in the year 2018 and 2 questions were asked in the years 2015 and 14 respectively. So if you look at this question that was asked in the year 2019, it reads, the 9th schedule was introduced in the Constitution of India during the Prime Ministership of. Now, this 9th schedule was introduced into the Constitution of India by the first Constitutional Amendment Act. And at that time, Prime Minister of India was Jawaharlal Nehru. And hence the correct answer here is A, that is Jawaharlal Nehru. Again, if you read about the second question, it reads, under which schedule of the Constitution of India can the transfer of tribal land to private parties for mining be declared null and void? So in this case, the correct answer is B, that is 5th schedule, because it is related to the protection of the rights and interests of the tribal population in 5th schedule areas. The question that was asked in the year 2018 reads that the Parliament of India can place a particular law in the 9th schedule of the Constitution of India, which is correct. And the second statement is that the validity of a law placed in the 9th schedule cannot be examined by any court and no judgment can be made on it. Now, this statement given here is incorrect because all the laws which have been included into the 9th schedule after the Keswananda Bharti verdict are subject to judicial review. And this aspect was provided in the Koilo case of 2007. And thus the correct answer is A, that is 1 only. And the question of 2015 reads, the provisions in the 5th schedule and the 6th schedule in the Constitution of India are made in order to. So as we all know that the main objective of these schedules is to protect the interests of the scheduled tribes. And the 2014 question reads, which one of the following schedules of the Constitution of India contains provisions regarding anti-defection law? So as you all might be knowing that it has been provided under the 10th schedule to the Indian Constitution. So after this, let us take up 2 practice questions that we have formed based on the important schedules of Constitution of India. Now, the 9th question that we have created reads that the 11th schedule was introduced in the Constitution of India during the Prime Ministership of. Now, in this regard, if you look at the options, you will find that Rajiv Gandhi, who was the Prime Minister of India, had taken up various steps for the introduction of Panchayat Raj institutions and the constitutionalization of these panchayats. And in this case, the Rajiv Gandhi government had appointed a committee to prepare a concept paper on the revitalization of Panchayat Raj institutions. And this was known as the LM Singhvi Committee. Again, the Rajiv Gandhi government introduced the 64th Constitutional Amendment Bill in Lok Sabha in July 1989 to constitutionalize Panchayat Raj institutions. However, it was only under the Prime Ministership of Narasimha Rao that 11th schedule got introduced into the Constitution of India by the way of 73rd and 74th Constitutional Amendment Act. And hence the correct answer here is B, that is Narasimha Rao. After this, if you look at the 10th question, it reads, which of the following statements is or are correct about the provisions related to the tribals in the Constitution of India? First is that the 5th schedule areas do not include any state from the northeastern part of India. And the second statement is that all northeastern states are included under the 6th schedule of the Constitution. Now, regarding the first statement, you should note that the 5th schedule of the Constitution deals with the administration and control of the scheduled areas and the scheduled tribes in any state except the 4 states of Assam, Meghalaya, Tripura and Mizoram. So, although the Constitution provides that the 5th schedule areas can be declared in some parts of the northeastern parts of India, the present position is that only 10 states are there in which the 5th schedule areas have been declared. And in these states, none of the state falls in the northeastern part of India. So, for example, these 6 schedule areas are lying under Andhra Pradesh, Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Odisha and Rajasthan. So, in this regard, the first statement that is given here is correct. That is, the 5th schedule areas presently do not include any state from the northeastern part of India. And regarding the second statement, the 6th schedule of the Constitution deals with the administration of tribal areas in the 4 northeastern states of India, that is the Assam, Meghalaya, Tripura and Mizoram. So in that case, this statement becomes incorrect because all the northeastern states are not included under the 6th schedule, and hence the correct answer that comes out is A, that is 1 only. So again, these 2 schedules which are related to the Indian Constitution and which are aimed at protecting the rights and the interests of the tribal population are important for us from the preliminary examination point of view. So with this, we conclude today's discussion, and in the coming week, we'll be taking up the last discussion related to the Indian polity. And in that, we'll be discussing questions from the political theory and also from important acts that have been in news which are related to the rights of the citizen of India. So keep revising from the political theory and important acts related to the rights of the citizens of India. And stay tuned for more videos.